Welcome to Trust Us, Estate Planning Wisdom, the podcast where we unravel the complexities of estates and trusts to empower you with the knowledge needed for effective estate planning.
This podcast is hosted by seasoned estates and trust attorneys, Danielle Friedman, Fineburg, and Charles Max McCauley.
This podcast is your guide to the intricate landscapes of estate planning, including wills, trusts, and probate.
Thank you for joining us, and we hope you find the discussion informative. But remember, when it comes to legal matters, always consult with a qualified attorney regarding your specific case.
Good afternoon. Hi, Max. Hi, Danielle. How are you doing today?
Hey, guys.
Fantastic.
So why don't you tell us, Max, what we should talk about today? I think you have a very special topic that a lot of people face all the time in deciding what to do about preparation of estate planning documents.
Yes, on this episode of Trust Us, we're going to discuss problems with do-it-yourself estate planning documents created using AI or online services. AI tools and online document preparation services can be very helpful for education or very simple planning. But estate planning is highly fact-specific, state-specific, and coordination-heavy. The most damaging errors often arise not from the appearance of the documents, but from missing asset transfers, inconsistent beneficiary designations, improper execution, overlooked family dynamics, and failure to coordinate tax, business, and incapacity issues.
Wow, that's a lot of things to consider. It sounds like a treacherous course to be doing it yourself. What are some of the execution formalities that you see, Danielle, that people should be aware of?
So every state has different formalities when it comes to making sure that your estate planning documents are valid, and that includes your wills, your powers of attorney, your trusts. Best practices is usually to have two witnesses and a notary for every document, even if your will technically can be valid if you just sign it and it's not witnessed. But for purposes of getting the documents accepted either by the court or by a financial institution, they have requirements that certain things be witnessed and notarized. And a lot of times, the execution formalities on the different documents, either generated by AI or various legal software that you find online, is deficient. And so attorney supervision is really important when it comes to execution. I mean, even when we prepare documents, we invite our clients to come sign them in the office, even if it might be inconvenient for them to travel to the office, because 99% of the time when we send documents out to clients and say, have this signed independently if you don't want to come to the office, and we give them all the instructions in the world and we color tab everything, things get missed, signatures get skipped, and then unfortunately it comes back to us and we tell the client. But if it's not coming back to us, or if a client is doing it on their own using AI or legal software, they're not going to know that things got skipped or missed, and then the document's going to be potentially invalid or rejected by wherever they're trying to submit it.
So they would take their will to what we might call a orphans court or a probate court or a surrogates court. And the clerk behind the desk is going to look at the document, and he or she is going to say whether or not it can be processed further for probate.
And sometimes, if let's say it's not witnessed and notarized and it's not what we call self-proving, which means it contains special language that the clerk can accept it immediately. If it's not a self-proving will, then you have to go and either track down the witnesses that witnessed it, or if it's not witnessed, have people sign attestations as to the testator's handwriting and of confirming that it's their signature. It's a big headache and it's a pain, and you can eliminate that completely if you have the right execution formalities. For me, one of the biggest issues I've noticed, formalities aside, is that clients are really looking to us for guidance. And when they use AI or when they use online document preparation services, they're not being asked the right questions and they don't know what questions to ask the AI. And that leads to deficiencies in their estate plan, whether it's a client that has a blended family and is in a second marriage and has children from two different relationships, or whether it's a client that has minor children, or all the different complexities that we see day to day in our practice need to be accounted for when doing planning. And a lot of times, those nuances get missed. It's really more of a one size fits all approach when it comes to online services or AI. And that's not what you get when you hire a credible estate planning attorney.
So one of the takeaways here is preparing a will and coordinating the assets in the beneficiary forms is a sophisticated process that requires a lot of thought and study. Going back to the execution issue, in addition to maybe not completing the document, not having the witnesses, not having the affidavits, one of the things I think about is the son or daughter who prepares a will for mom and dad and presents it to them. How does an attorney help in dealing with the issue of whether the parent had capacity, whether the parent was suffering from undue duress, whether the parent was acting independently? Max, what is missing if it's just printed out and presented to the parent signs it, but there's no legal supervision?
Right, well, you've missed an excellent opportunity to avoid what could be a very expensive court battle over capacity. The attorney can do many things, including have a transcript of the signing, a videotape of the signing, where the attorney is asking certain questions to establish competency of the folks that are signing the documents. But if that's not handled up front and it turns into a court battle, the entire estate could be spent earning fees when people are fighting over whether or not there was undue influence or capacity or duress, or did mom and dad actually make a meaningful choice. Herb, on a different topic, when you said coordinated, something we often see is that the business interests are not coordinated with the estate plan. Sometimes the estate documents are going to conflict with operating agreements or shareholder agreements, buy sell agreements, or maybe even violate S corporation transfer restrictions. Another issue we see a lot of is that the LLC interest passes in a way that violates the operating agreement's transfer restrictions. So if you had an attorney involved and they looked at your business interests and, again, Danielle, to your point, knew to ask questions and take a good list of your assets and your liabilities and what you want to do with them, you will, in that process, review those governing documents alongside your estate planning documents to make sure they're coordinated. Another issue that I think could flow out of that is that tax opportunities or tax traps are just simply missed. AI or your online planning software won't know to ask those questions or give you that advice.
Or sometimes it recognizes issues but gives you incorrect advice. We've all used AI, and I occasionally will ask it some questions and it will give me a completely made up number when it comes to the federal estate tax exemption or something as simple. And that's really a Google search. I'm frankly surprised when I have asked AI, what is the 2026 federal estate tax exemption, just for my kind of verification purposes to make sure it's thinking correctly. And it'll give me some completely made up number when in fact it's 15 million. And if you just Googled it, that's what you would find. You have to take everything it says with a grain of salt. And I think that the human touch and the experience that we bring to the table is really critical. We're not just trying to sell legal services. We are here because we know the different moving parts that need to be addressed when it comes to preparing a comprehensive estate plan.
Well, let me ask you a question. We were talking about coordination of business interests. What happens when dad says he wants to have the business interests go to each one of his children in equal shares, but the contractual business interests, the operating agreement for the LLC, the shareholders agreement, those things say a different arrangement? Which one controls? Is it the will or is it the contractual documents? And why does one trump the other one?
I think the contractual documents are going to trump because that's the business deal that you struck with your other partners in the business or the other members of the LLC. They're not bound at all by your estate planning wishes or desires unless they're in the contract, in the operating agreement, or in the partnership agreement, or in the shareholders agreement.
So a judge would enforce what the business deal is between the partners, and the judge would say, I see what the will says. That's not effective.
Correct.
Yeah. And the same is true. I have clients that come to me who have prenuptial agreements. And maybe during the course of negotiating the prenuptial agreement, they said they agreed to leave their spouse a certain percentage of their estate or certain assets. And then if the will says something different, then the spouse has a contractual right to whatever was agreed upon in the prenup. It doesn't matter what the will or the trust says, they can go to court and enforce the prenuptial agreement because that's the promise you made first.
And would that apply also to a divorce decree and a property settlement? What would trump the will or the divorce decree?
The will is always sort of in last place. I mean, even we have clients who have beneficiary designations that may contradict their estate plan. And I always tell my clients there's a hierarchy as to how assets pass at death. And the beneficiary designation always controls over the will. So make sure your beneficiary designations are updated. And part of having that human touch is explaining that to the clients, educating the clients, and then also making sure it gets done.
Max, I think you've had a couple of cases where the children come in and they have retitled the assets in joint names with the, say, the surviving parent. And maybe it's just one child in there. What happens when the will says, I give it equally to my four children, and the asset is titled in a joint tenancy type of arrangement? What happens there?
Unfortunately, the will again is in last place and is going to be ignored.
Oh,
If you added, your daughter for convenience to help you pay the bills on the house, then it's going to go outright to the daughter, even though your will might have said that all three daughters should share equally in the house.
so it sounds like the will is in last place no matter what happens if you don't coordinate beneficiaries, the assets, the contracts. If somebody's not looking at all those things, preparing a will could be a foolish waste of time.
And then we will always coordinate. Your estate planning attorney is going to coordinate with your CPA and your financial advisor because your financial plan needs to be thought of, your tax returns need to be thought of. Otherwise, again, you're going to run into the missed tax opportunities or tax traps. And something you had mentioned with AI, we see this often. AI will blend the law of multiple states together when it gives you advice. And I can tell you, I'm admitted in 4 states, and the estate planning laws and the fiduciary code of each of these states is very different. And it's that way for all 50 states. Some are similar, some are very different. And AI does not draw that distinction between and among the 50 states. They'll cite to incorrect statutes. We've all heard of hallucinations. It'll cite to cases that doesn't exist or statutes that doesn't exist or exemptions that are just wrong. Or again, it's blending the law of multiple states. I think to your point, Danielle, it is unable to ask follow-up questions, whether it's family dynamics, a special needs child or a family member that needs to be taken care of instead of potentially harmed by bad planning.
Yeah, all of these websites and ways of preparing wills do have typically a prominent disclaimer. What do they say when you're using this document?
That they're not being reviewed by an attorney or
They're not providing legal advice.
they're trying to exculpate themselves of any liability to the extent the plan isn't what you expected it to be. And it really is a DIY, proceed at your own risk type of exercise. It's interesting because even though we are estate planning attorneys, our practice is comprised of tax, special needs planning, asset protection, business succession planning, real estate issues. So it's really a holistic practice. And when you are trying to DIY, you might end up with a will, but it's not planning. It's not the same thing as estate planning. It's document preparation.
So that will that they prepared based upon a DIY website is likely to result in bad results because
Overconfidence. It looks good. It looks thorough and detailed.
and then what the parent is saying to the children, for example, you will each share equally. And that doesn't happen because the beneficiary forms trump, the buy sell agreements take precedent, the assets are improperly titled. Does that estate administration end up?
Inc- And it ends up being extraordinarily expensive. And any money you thought you saved in using a DIY tool rather than paying an estate planning attorney is out the window. We've cleaned up a lot of messes that have been brought to us, and oftentimes it's at least 10 times more expensive than what it costs to create the mess, if you will, and create the poor documents and the bad drafting or the uncoordinated estate plan that ignores the business needs or something like that. It is always more expensive. It's significantly more expensive to correct and undo mistakes.
Have you ever seen AI produced documents or online DIY documents that don't have serious material flaws, problems, cost, issues? Have you ever seen them turn out to be appropriate and on point?
No, they get brought to me rarely these days, but the only time I can think of is when it would work out is if it's first marriage, clients are elderly, they've been married a long time, and someone creates an I love you will and just leaves everything to their surviving spouse. But in the meantime, everything was probably jointly owned anyway and was going to the surviving spouse regardless. They might have not even needed the will, but that is such a rare event. And frankly, people come to us and say, "Oh, I'm just going to leave everything equally to the kids." And it's like, well, is that even a good idea? It's a business. Do you really want your kids owning the business equally? If one is more involved, maybe we figure out how to make one child whole while not leaving them the business and really talking through the client's goals and needs, which I think that's really what gets lost when you use online tools instead of working with real human beings.
It sounds like there's one thing about preparing a will.
Yeah.
And what I'm hearing from you, Danielle, there's estate planning. There's develop plan with what you're going to do with what you spent your entire life building up for the next generation. And it can't be solved without any planning by just simply printing out an online will.
And it's worse than that, right? They're going to do the will, but what else should they have done or considered in addition to the will as part of their core estate planning document?
Right. You need powers of attorney for healthcare decision making, and those are really state specific in terms of their validity. So it's important to make sure you have an attorney preparing those and knowing what rights you're granting to someone under a power of attorney because they can be very broad and you can be giving someone the ability to manage your assets and not even know what you're signing. So it's important to get good counsel and
So you're
yeah.
talking about talking to somebody about who would be a good person to be an agent under a power of attorney? Who would be a good person to be an executor or trustee? It's not just your best friend. It might be somebody who you think can almost step into your shoes and try to mirror your attitude and has some sense of responsibility for what their job is.
Yeah, I mean, these are people who owe you and your beneficiaries a fiduciary duty, and you want to make sure that you're selecting someone who's qualified to fill that role. What we do is a lot more than just word processing, I think, is what it comes down to. The document itself is important, but it's not the most important part of what we do. I think we want to convey the plan in writing eventually, but I think doing the planning and talking to the client and educating the client and figuring out what works best and what makes sense for each specific family is the most important part of that. And you just don't get that when you are using an online tool. And some people come and say, oh, well, that's all fine and well for people who have business interests and complexity and second marriages and multiple children. But I'm happily married and I have 2 kids from the same marriage. And I just want everything to go to my spouse and then to my kids. And I tell those people the same thing. You might not achieve that outcome with what you are currently putting into AI or LegalZoom or anything like that.
Now, I do think AI and even online tools can be useful for basic education, but it's not a substitute for legal advice. So I don't want to sound too negative on AI or online tools. I think they can provide you some necessary background, but if you rely on them completely, what I have typically seen is they never get revised, and we don't see the problems until you're dead. And when you're dead, it's too late to fix most of it, at least to fix it cheaply. It's going to be a lot more expensive. And so to that, and we've said in other podcasts, you should look at your estate planning documents every, say, 3 to 5 years. Every time there's a life change, an event, marriage, a divorce, birth of children, death, disability, business sale. Maybe you change states, residence, but you need to look at it. And when you do that, bring those AI created documents or online created documents to your new estate planning counsel and let them look at it. And they will uniformly point out issues that were missed.
Yeah, I think it's sometimes penny wise and dollar foolish. Just these tools at the end of the day, this is your final statement for what you are leaving behind. And don't rely on AI or someone without expertise in this area. I think it's important to have that peace of mind and make sure that your plan makes sense, conforms to your wishes, and ultimately achieves your goals in a hopefully tax efficient way. And I think only an attorney can really give you that peace of mind.
And minimize the cost of estate administration. I'm recently admitted in Florida, right? And the common Florida example is you own real estate outright in Florida instead of through a revocable living trust. You might be a Pennsylvania resident, but then you end up with an ancillary probate action in Florida that is court supervised and very expensive to transfer any piece of real estate you have. Whereas if you'd used a revocable living trust in Florida, you might have avoided probate and saved yourself tens of thousands of dollars in estate administration costs. It's just one example, but if you brought it to a lawyer, they're going to give you those tax savings or estate administration savings, probate savings. And again, they're always going to save you more than it's going to cost you to have a good core estate planning session with your lawyers, especially add in your accountants, your financial advisors, and others to make sure that it's a fully coordinated plan.
Great. That was a good summary of all of the issues that you could face. There's probably many more that we haven't thought of, but do you think we've covered the topic okay?
I think so. Hopefully, people realize the risk that is involved with using these tools and always reach out to counsel if you have any questions.
As we said before about overconfidence, it's not that the documents look wrong, it's what they haven't considered or the choices that they made. They look really good. They look like they're thorough, and you're going to feel confident about them, but they're not.
All right.
Thank you.
Thanks, everyone.